Good morning, it's Alex Woods here. I think that the answer to this question is rather an interesting one because, if you're a geeky lawyer that is, obviously if you're an insolvency practitioner you just want a practical answer to the simple question, which I will come on to. I'm going to give you two examples of cases in action relating to this issue of whether or not payment protection insurance claim can be considered an asset at all. I'm going to start with an introduction in relation to the guidance note and other authorities on the issue, and then I'm going to wrap up with a conclusion. It's interesting, reading some of the other authorities, if you like, prior to the guidance note, one might have thought that the issue was well and truly dealt with. PPI is an asset and it should be available therefore to the IVA supervisor for purposes of introducing it into the IVA. Now, whilst that clearly is the accepted position in respect of bankruptcy, that's not necessarily the case in respect of an IVA. Now, the authorities that I've referred to, one's counsel who surprised everybody not so long ago by announcing that he didn't consider that the PPI was excluded, that he felt that it could be treated as an asset for purposes of the IVA. And the other one is a rather helpful whistle-stop tour. Well, more than a whistle-stop, it's quite it's quite comprehensive. Compliance on Calls blogspot on the issue, and they also suggest that the insolvency practitioner should treat the PPI as an asset, both because it's not specifically excluded, and also because it could be treated as an after-acquired asset. Now, unfortunately, now the guidance note, or fortunately, whichever way you want to look at it, the guidance note is pretty clear, in my view, that, okay, as far as bankruptcy is concerned, as far as the R3 standard terms and conditions are concerned, then, and as far as the general protocol, which has a all assets clause in it, is concerned, fine. PPI is to be considered an asset that's available to the IVA supervisor. However, there are two things to note. One is the guidance note puts in bold in 2.3, in an IVA, it is vital that supervisors check the terms of the proposal in each and every case before instituting PPI mis-selling claims or demanding the proceeds of such claims. So it can't be avoided. You will have to look at the individual terms and conditions of the IVA in question. You would have hoped to have avoided having to do that at all and just to treat the bloody thing as an asset, but you can't, because in respect of your general the general protocol standard terms and conditions, where there isn't an all assets clause, you are going to have to look at the individual terms of the IVA proposal, and you are going to have to struggle with the knotty problem of whether it's PPI is included as an asset at all. The guidance note mentions a couple of kind of caveats, which is there's nothing stopping the debtor making available any PPI claim to the IVA, and also there may obviously be buried in the individual IVA proposal an additional income clause. So with that in mind, which is, I suppose, well, I'll summarise at the end. So I'm now going to look at a couple of practical examples that I've had to deal with in respect of PPI claims that we'll be making on behalf of IVA supervisors and our debtor clients. And so there are two examples. The first one is an IVA that is post 2009, and where it was quite a unique. I mean, most IVAs are quite tailored to individual clients' individual circumstances. This was especially unique insofar as the debtor had a business and had clearly specified within the terms of the individual voluntary arrangement that provision of how their liabilities to the creditors under the IVA were going to be met. They were going to be met in three ways. They were going to be met because there was a legal action ongoing against someone, of which might generate substantial proceeds. There was a professional involved in the business who owed money, and there was also loans to the company by the directors who were the debtors in respect of this joint IVA, and it was anticipated that these loans the company might be able to repay those loans to the individuals in question, and therefore they might be able to repay their creditors. And the IVA was only for a one-year term. Moreover, it gave a couple of examples it gave a worst case and a best case scenario of 31p in the pound approximately and 7p in the pound approximately. So it gave those to now. As far as I was concerned, from a practical point of view, I was only brought onto the scene when the IVA was about to complete, and now so therefore I considered the question is and there's quite a large amount of payment protection insurance, believe you me, across all of these creditors. It was 6 figures worth of creditors, 6-figure value worth of creditors, and there was probably quite substantial, perhaps as much, in potential PPI claims against a large number of creditors. So the question was it an asset? Well, okay, it is not bankruptcy. It is not R3 standard terms and conditions. It was an individual tailored proposal, but which included the insolvency petition, included the protocol standard terms and conditions, and put them onto their own letterhead, so to speak, but they were basically the same. And therefore there was no all assets clause, and therefore it is starting to look as if there might well be an argument to say that the PPI was not an asset that could be realised to the benefit of the IVA. And I came to the conclusion that in all the circumstances, and since the debtors had completed or were about to complete on the best case scenario, and I think you do have to look at the extricable, the whole. You have to look at the whole situation in the round, and it was about to complete, and the proposal had been, as I say, quite specific in providing for, specifying, prescribing the source of funds. And where the funds would be coming from in order to meet the obligations under the IVA. And I think therefore one could infer that a payment protection insurance claim was excluded because, in short, the IVA proposal was so specific. It was such a specific IVA in the case of these two debtors, and they had honoured the terms of the IVA and they were about to complete, etc., etc. So it hasn't come to a battle yet. The creditors, even when we pursue PPI claims against them post-completion, may argue that the PPI claim, is an asset. And I refer you to my previous video bulletin in which I read out an extract from a letter from Capital One, who are a non-status outfit who make a weak case as strong as they possibly can, and accuse our client, this is another case, of not making full and frank disclosure of the fact that they had an asset at the time that the IVA was set up, even though it was set up in 2006 when no one really knew about the PPI scandal. So I may run into those sorts of arguments down the line. If I do, I will be arguing with the respective creditors that, you know, not only can't you set off this PPI claim under the terms of this individual proposal, and I'm the the lawyer representing the debtor client and working with the IVA supervisor, we don't consider that this is an asset that can be clawed into the IVA in the first place. So F off. So that's how. Now the second example is again obviously a post 2008 example, a IVA protocol standard terms and conditions article, and the fact of this one, it was more of a standard IVA. It was quite a high P in the pound, 47p in the pound, and it made provision for it had a the house was excluded, but the debtor was had undertaken to to remortgage the property and to pay a certain amount of the remortgage proceeds into the IVA at the end of the term of the IVA. So a type of IVA that many of you will be familiar with. Now, in those circumstances, one might argue, because again I couldn't find an all assets clause in the IVA, and therefore I'm tempted to say that the IVA in this case, there was no additional income clause. This was an IVA where the debtor had been fully compliant with the terms of their IVA, and a lump sum had been paid. In fact, the IVA had been realised early, much earlier than was envisaged, by the payment of a large lump sum into the IVA, and as I say, 47p in the pound. I'm not sure, to what extent technically, legally, you would look at the p in the pound. But as I say, my view is you've got to look at this thing in the round. You've got to make sure everyone's happy with the arrangement, that the creditors don't feel shortchanged and the debtors don't feel as if they've been hard done by. So now, what was interesting about this IVA, and just shuffling papers to try and find the clause, but I can remember it anyway. There was a clause in it, and it was a windfall clause, which you would expect, as per the guidance note, is an after acquired asset or windfall clause. And since the payment protection insurance was not after acquired, it may have been, it's just simply been after realised, but it's not after acquired, like they've come into an inheritance. It was always there. It's just a question of whether or not you're realising it. Anyway, there was an after acquired windfall clause, which one would normally ignore post guidance note relating to this issue. But this particular clause is drafted in such a way that it talks about, and it uses the word for the avoidance of doubt, this can include personal proceeds of a personal injury claim or settlement. So it starts to stretch in the case of this particular IVA proposal. Again, refer to the guidance notes. You've got to look at the individual terms of your proposal above all. It looks as if actually it is an asset of the arrangement, because a PPI claim could be called a settlement. There are arguments around that, but I think for our purposes, the debtor would probably envisage a settlement to be of that, a PPI claim. Yeah, I think it would probably fall in the category of a settlement. Going forward, I'll probably fight that. We haven't got too far down the track with this case. We're still simply obtaining all the documentation before we deal with HSBC, who have sort of a priori simply decided to set off a reasonably large amount of payment protection insurance against their own debt. Okay, they haven't even introduced it for the benefit of all the creditors. So before I even come on to the argument of whether or not I feel that they're entitled to set off, which will be the subject of another video bulletin, there is a question mark over whether it's an asset at all for purposes of inclusion in the IVA. And I'm tempted to say in this one, I think I'll fight the debtor's corner, because it was a high P in the pound, and they were very responsible in dealing with their liability to creditors and complying with the terms of the IVA, and they went through the lengths of getting a large amount of third-party money to settle the IVA early and in full. And I think in those circumstances, there's a fight to be had. So those are the two examples. Now to conclude, I think that, as I say, you've kind of got a list here, haven't you? You've got an asset. If it's a bankruptcy, it is even after the bankrupt's been discharged, you can treat it as an asset for purposes of paying to the creditors. If it's a R3, sound terms and conditions, then it'll have an all assets clause, so it can be introduced into the IVA. If it's a protocol terms and conditions, then there's an argument to be had, and one would look to see whether or not there's an all assets clause in the IVA proposal. One would look, as I say, at these issues 2.5, 2.6 that the practice note refers to in relation to any other additional income clause. But ultimately, my view is that one has got to take an equitable approach to the issue and look at the matter in the round. And I would now say at this juncture that the PPI scandal is something of an oil slick. And I feel that the IVA supervisors are in the nature of, remember that massive oil slick off the coast of Mexico, I think it was, or was it Louisiana? Anyway, it's a massive oil slick quite recently, wasn't there? And, IVA supervisors are the tugs, the poorly paid, probably reasonably badly maintained tugs that have got to go around spraying this detergent on the sea in order to clean up this oil spill. It's a similar thing in the case of financial mis-selling claims. No one had envisaged the nature of the payment protection insurance scandal and the problems that it would cause, and the particular problems it causes to the insolvency sector, and the amount of time and work and payments to third parties like me in audit fees that you've then got to shell out to deal with the problem that's not of your making, and it wasn't envisaged when your creditors signed off or added their modifications to the IVA at the start. So I think the final note is you should be belligerent, bullish about reconvening the creditors and getting yourselves paid properly for having to undertake this, for dealing with this oil slick. And, even where creditors made modifications, unless they're very recent modifications, you should challenge these. And I think you should be prepared to go to court and ask the judge, Your Honour, is it not fair that we be properly compensated for having to deal with an oil slick problem, the scandal that's not of our making? And I bet that in 7 times out of 10, the court would side with you. Many thanks for now, and look forward to posting the next question in this 10-episode series. Post-guidance note, best practice post-guidance note. Have a good day.